Hello, welcome. Dr. Michael Arnheim here again. Today I want to talk to you about quite an important case that went to the UK Supreme Court in 2020. It's called Barclays Bank and various complainants. Barclays Bank against various complainants, 2020, because these complainants, 126 innocent victims, were suing Barclays Bank for sexual assault. Not that the bank assaulted them, but Dr. Bates, who was actually appointed by the bank to perform medical examinations on these 126 innocent victims. They were all young ladies, young women. The bank was being held liable for the sexual assaults which were proven by Dr. Bates, who was long dead. Now, what happened was Dr. Bates was not employed by the bank as such, but he was used by the bank. He was engaged by the bank to examine these young women after they had had a successful interview with the bank, and all that was needed before offering them a job with the bank was a clean bill of health from Dr. Bates. Now, Dr. Bates was a GP in private practice, and he actually performed the examinations at his home address on behalf of the bank. That was all arranged with the bank. The appointments were arranged by the bank, and Dr. Bates prepared a report on each applicant headed Barclays Confidential Medical Report. And he was paid separately for each report. He was not on a salary or anything like that. At first instance, in the High Court, the bank was found vicariously liable for Dr. Bates's proven assaults. And that result was affirmed by the Court of Appeal, but was reversed on appeal to the UK Supreme Court. The UK Supreme Court reversed that decision on the basis that Dr. Bates was not an employee of the bank, quote, nor viewed objectively anything close to an employee, unquote. And so the bank was off the hook, and these 126 young women got no compensation whatsoever. They lost the case, and it was cold comfort to them that their names were kept confidential. But they lost the case after winning the case twice in a row. Now, why did that happen? What is this vicarious liability? Well, it's most usually found in areas of employment where an employer is liable for the wrongdoings of his employees. That is vicarious liability in tort. T-O-R-T, tort, meaning wrong. The French word meaning wrong, coming from a Latin word meaning twisted. So an employee certainly would transfer the liability to the employer in a case where the employee did wrong and was working for an employer at the time. But it's not the only category of vicarious liability. Vicarious liability is actually extremely common. Yes, in employment, but also, for example, in agency. If one person is the agent of another, the principal, as it's called, is responsible, is legally liable for the wrong acts of his agent as well. And this kind of liability, which is called vicarious liability, can even apply to criminal activity, where an employee or an agent is guilty of a criminal activity. The employer can be held liable in certain circumstances. That's vicarious liability. It's related to the word vicar because a vicar is in the church is somebody who is the deputy to a bishop. So similarly here, standing in, it's one person standing in for another. Vicarious liability is where one person stands in for another and takes the rap for that other. And there's a very old Latin maxim saying that respondeat superior. Let the superior person respond, be responsible. Let the boss take the rap, in other words. Let the boss take the rap. And it's a very fundamental legal principle. Now, all right, Dr. Bates was not, the Supreme Court found, was not an employee of the bank, but the lower courts had found that although he wasn't actually an employee, he was acting in the nature of an employee. His work was very similar to that of an employee because of the arrangements made by the bank, the forms, the way he was paid, and all that. He was acting in a similar capacity to an employee. But the Supreme Court said no. But the Supreme Court did not actually consider another possibility, which is that Dr. Bates may have been acting as an agent of the bank. My own view is that he certainly would have been in that position. He was acting on behalf of the bank with very strict instructions and forms and arrangements made by the bank. If he was not acting in the nature of an employee, then surely he was acting in the nature of an agent, and the bank should have been held liable. Instead of that, they weren't. We have a complete reversal of the first two decisions then by the Supreme Court. A rather worrying development. And I'm glad to say there is one senior, very, very senior judge in this country who has come out and identified a problem in the whole area of tort, which, as I say, is not just the tort of negligence, but these other torts as well. Because this tort, in this particular case, Dr. Bates assaulted these young women. That is a crime and a tort, and it's a deliberate tort. And this judge, Lord Neuberger, who is now retired as the president of the UK Supreme Court, has actually come out and said that there is disarray and a marked lack of reliable principle. Disarray and a marked lack of reliable principle in the field of tort. Well, that is very worrying. He also called on Parliament to give guidance to the judges. because otherwise judges would make up the law as they went along. To blame the judges, he said, in an interview this was, for making the law when Parliament has failed to do so would be unfair. And I agree with him. Don't blame the judges. But as he said, and this was in a lecture, there is disarray and a marked lack of reliable principle in the field of tort. Why? Because the law isn't clear enough. Nature, as we know, abhors a vacuum. So that means when judges find the law is unclear, there's no law, they step into that vacuum. They step into the breach. In this particular case, the first instance court and the Court of Appeal went one way on the law, and the UK Supreme Court went in the opposite direction. That's not a satisfactory situation. And these 126 women got nothing, no compensation for these proven assaults. Very bad result. Yes, their names were kept confidential, but that was cold comfort to them when they got absolutely no compensation at all. In a situation where I think they really ought to have, and so did all the judges who heard the case up to the Supreme Court. So what should Parliament do? As I say, I don't blame the judges, but it is time for Parliament to give more guidance on the law by passing legislation. We don't have a codified system of law in this country. There have been attempts at it for many years, but it's never got very far. Whereas in America, for example, every single state, even the smallest states in America who have well under 1 million inhabitants, each state has a codified set of laws. And they belong to the same common law tradition as we do, but they've got codified law. So in any given case, the court knows where to go. The court has guidance in the form of the code. Why is there nothing like that here? It is time that Parliament stepped up to the plate and actually legislated on basic law, preferably in the form of a code. Thank you for watching, and there'll be more next time.